Straight ahead on Law&Crime Daily. Chaos in the courtroom as the judge makes a decision in the murder trial of an Olympic gymnast's brother. Prosecutors of the so-called Doomsday Mom fire back, calling requests made by the defense absurd. The latest on Lori Vallow Daybell after she's ruled incompetent to stand trial. Should Derek Chauvin's request for a new trial be denied? What you need to know before the ex-cop is sentenced for the murder of George Floyd. Plus, the infamous cadaver note revealed to jurors in the Robert Durst trial. Could the letter hold clues as the real estate heir stands charged in the death of his best friend? Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmire along with Terri Austin. We begin with the tense moments in a courtroom in Cleveland after a judge throws out the murder case against the brother of Olympic gymnast Simone Biles. Angenette Levy is here with a body cam video that was recording in the courtroom.
Brian, Tevin Biles Thomas faced a long list of charges related to the deaths of 3 people, but the case ended in dramatic fashion when the judge granted Biles Thomas's request for an acquittal.
The sheriff's deputy's body camera had just been activated, so you can't hear the sound, but you can clearly see a man stand up as a woman sitting in a chair drops her head in disappointment. Then the mother of one of the 3 people who died in the New Year's Eve 2018 shooting rushed the defense table, yelling, "I'm going to kill you," at Biles Thomas. Sheriff's deputies stopped her.
Get back. Get back.
This was the second trial for Biles Thomas. His first ended in a mistrial last month after the jury reported receiving documents during the deliberations that discussed Biles Thomas's possible defense. This second trial ended with the judge granting the defense request for a judgment of acquittal and tears.
All right, let's clear the courtroom. Let's clear the courtroom.
Biles Thomas and his famous sister, Simone Biles, were raised by different family members. In 2019, Simone Biles tweeted asking for privacy and saying her heart ached for all involved, especially the victims and their families. She is on her way to the Olympics, and now her brother is a free man over the objections of the victims' families.
You a hoe, man.
Come on.
And the woman who ran toward Biles Thomas was not charged. The judge did not hold a hearing to see whether or not she would be held in contempt or not. Brian?
Thanks, Angenette. Joining us today is presidential partner and attorney Tammy Allison and co-host Terri Austin. Tammy, what's your reaction to the judge not holding anyone in contempt for that outburst?
Hi, Brian and Terri. Thank you for having me. I believe that the judge understands that in these types of emotional situations where there is a victim that is deceased, that there could be emotional outbursts as we've seen here. I do think that the judge's decision not to hold her in contempt was appropriate, given the fact that she had just heard that news and was hoping that there would not be an acquittal so that there could be justice for the victim and the victim's family.
Terri, what do you think? Did the judge make the right call here in terms of evaluating everyone's emotions as Tammy is talking about?
Oh, I definitely think the judge read the room well and made sure that she didn't hold anyone in contempt, because it's a difficult judgment to listen to when, in fact, one of your relatives has been killed. Whether or not the judge made the right decision is difficult to say. This was a full acquittal. It wasn't a dismissal without prejudice. And the one thing the judge said was that she was looking at the evidence in the light most favorable to the state, but she said that it was 75% accurate, which I don't think she should have said. She should have just simply said that the evidence was insufficient to sustain a conviction and left it at that. I think it was that piece of information that upset the woman in the courtroom, the relative.
Yeah, the judge did take a point to say about the identification procedures and how whether or not it was 75% accurate that this was the defendant who committed this crime or not. Angenette, have you ever seen a judge grant a request from a judgment of acquittal?
You know, Brian, I've covered a lot of trials over the last 16 years or so, and I've never seen a judge grant one of these. It almost seems like a formality most of the times. The defense attorney does this because that's their job, and they have to say that the state didn't prove its case. But you've seen judges maybe at a bench trial find a defendant not guilty, and you've seen juries find a defendant not guilty, but I've never seen one of these granted.
Makes sense. Now we'll continue. Thank you, everyone. Now to Colorado, where jury selection is continuing for a fourth day in the trial of a father accused of murdering his son. 13-year-old Dylan Redwine vanished over Thanksgiving weekend in 2012. In 2017, a grand jury indicted Mark Redwine for second-degree murder and child abuse resulting in death. According to court documents, Dylan reportedly found compromising photos of his father, including him wearing women's clothing and eating feces from a diaper he was wearing. Potential jurors are now being individually questioned about their possible knowledge of the case. Opening statements are scheduled for Monday afternoon. Be sure to tune in to Law&Crime Network for gavel-to-gavel coverage. And in Georgia, a father convicted in his son's hot car death has been denied a new trial. Host of the Law&Crime show, Prime Crime, Jesse Weber, explains.
Hey there, Brian. It's the Justin Ross Harris case. This is the father who killed his toddler son by leaving him in a hot car. The question is, was this an accident or murder? To help us figure that out, we go to one of the most revealing and unpredictable police interviews we have ever covered on the show.
I pulled in, I pulled him out, and for a few minutes, I guess what would seem an eternity, but for just a few seconds, I attempted CPR. I couldn't compose myself to do it.
And that's just part of the story. There's a lot more to this Georgia father than meets the eye. Tune in to Law&Crime.
Thanks, Jesse. Be sure to check out Prime Crime with our very own Jesse Weber. Still ahead on Law&Crime Daily, strong words from the prosecutors of the Doomsday cult mom, now deemed incompetent to stand trial. But first, the murder trial of Robert Durst continues. The evidence in the death of his best friend you don't want to miss. Welcome back. One of the first detectives to investigate Susan Berman's death takes the stand in the Robert Durst trial and testifies about the infamous note sent to police about a cadaver. Susan Berman was gunned down at her home in California in December 2000. Investigators say there was no evidence of forced entry. 15 years later, her best friend Robert Durst was arrested for her murder. Prosecutors say Durst shot Berman because she threatened to go public with information about Durst's missing wife, Kathy. On the same day as Berman's death, a letter was sent to the Beverly Hills Police Department with the word cadaver.
The detective from Beverly Hills PD that told me that he had learned about the murder of Susan Berman and that he had received a letter with a note inside, or an envelope with a note inside of it.
Okay.
He thought was going to be of interest to me.
Is that a photograph of the letter that was inside the envelope before it was sent out for processing, forensic processing?
Yes, it is.
And is that the envelope that you received from Beverly Hills Police Department?
Yes, it is.
And I assume it did not appear like this in terms of the coloration, discoloration, and the other residue from forensic testing at the point in time you received it. Is that fair?
No, it was clean.
And they were sent out for DNA analysis?
Yes, it was.
Were you able to get any DNA off the envelope?
No.
Or the letter?
No.
On cross, the defense asked the detective about possible contamination at the crime scene, including when two people broke into Berman's home.
Found that out, yes.
Okay. And there were actually two people who were able to get into this secured house. Isn't that true?
Yes, it is.
Okay. Did you leave the windows unlocked?
No, I don't believe I did.
Okay. Did you observe any other officers leaving the windows unlocked?
No.
Okay. And of course, between the first visit, the second visit, and the third visit, people besides law enforcement were going into the house, correct?
That happened, yes.
Okay. And that really jeopardizes the security of the scene for purposes of evidence collection, doesn't it?
It can.
Do you recall that the interior door in the room where Ms. Berman was found had chips on the floor by the door jamb?
Yes.
Okay. Did you dust that area for fingerprints?
I don't recall.
Okay. Did you check that area for hair fibers?
I don't recall.
Did you do anything to secure that area with respect to DNA?
No.
On redirect, prosecutors asked if it was unusual for no forensic evidence to be collected inside the home that may have linked Durst to Berman's murder.
I want you to assume that the defendant was in the home, saw the body, picked up things off the desk, wrote a note, all inside that home, and actually was inside that home. Notwithstanding that fact, assuming that's true, are you saying there was still no forensic evidence saying he was there?
None was obtained.
Okay. And is that out of the ordinary for you, that someone might admittedly be inside a home but not leave a trace? Is that out of the ordinary?
No.
Thank you.
All right, additional cross-examination.
But you really didn't take everything, did you?
Excuse me?
You didn't really take everything to have it tested, did you? You left the newspaper, correct?
There was things left, yes.
Okay. You left the envelopes that were on her desk, correct?
But I did not have any clue what I was searching for at the time. I had a person who was executed laying on the floor.
What's interesting about this, as the defense attorney and prosecutors are talking about what is or is not unusual in an investigation, you have a prosecutor, John Lewin, changing the urine bag of Robert Durst to make sure this trial goes ahead. It's going forward no matter what. Just wanted to throw that in. But Terri, let's dive into some of this testimony. Detective Roberts was the lead detective on the case. Was this an important witness for the prosecution?
I think he was a solid witness, Brian. I don't think he was perfect. Obviously, there were some discrepancies as far as the investigation was concerned, but he was the first one on the scene. He was the lead detective. He did a thorough search. He established the fact that the premises had not been broken into. Nothing looked like it was disheveled or that anyone had robbed the place. So I think he did establish those things for the prosecution. And he did say that he sent many of the pieces of evidence to the lab for testing and that he didn't get anything back on, for instance, the shell casing. So he was solid. He wasn't perfect, but he did a good job.
Yeah, so tell me, he did all of those things well, but the defense poked a lot of holes in an investigation about contamination and people breaking in. But was that enough to cause reasonable doubt in this case?
I believe it could have been enough. I mean, the fact that he questioned him and questioned the fact that he did not take fingerprints, he didn't take the envelopes off of her desk. There are so many things that he could have done that he did not do. And we have to remember here that there really is no evidence tying Mr. Durst to the murder of Susan Berman. All we have is circumstantial evidence and motive, and the motive is circumstantial at best as well. So I do believe that the defense did a really good job of poking holes into the prosecution's case to create doubt. And we all know that the burden of proof is beyond a reasonable doubt.
It's going to be a very interesting summation when they put all of these pieces after weeks and months of testimony together to see how it all kind of ties in. It's going to be something to watch. Make sure to check it out. Law&Crime's got you covered for gavel to gavel cover there. Coming up on Law&Crime Daily, should Derek Chauvin be granted a new trial for the murder of George Floyd? Plus, the request made by attorneys for Lori Vallow Daybell as she is moved to a mental health facility. White prosecutors are calling them inappropriate. Next. Welcome back. Prosecutors of the so-called Doomsday Mom are calling a list of demands made by attorneys for Lori Vallow Daybell absurd. Terri has been closely following the case and is here to explain the latest update in the Doomsday Cult couple saga.
Brian, this is all because Lori Vallow Daybell was deemed incompetent to stand trial just weeks ago.
Lori Vallow Daybell, along with her husband Chad Daybell, are facing murder charges in connection with the deaths of her two children, J.J. Vallow and Tylee Ryan, and the death of Chad's first wife, Tammy. Chad is pleading not guilty, while Lori's case is on hold for now. According to East Idaho News, Means is claiming in court documents that Lori Vallow Daybell is in a fragile mental state of incompetency as a direct result of the historical and systemic mental, emotional, and physical abuse she suffered. Means is requesting to be directly involved in her treatment and for the names and credentials of all people involved in her care and the medication and proposed plans. But now, Prosecutor Rob Wood is firing back in court documents. Wood says he informed Means about a call he made with the Idaho Department of Health director about Lori's treatment. He's asking the judge to deny the defense's motion, calling the request unfounded and legally unauthorized.
Terri, Wood is adamantly objecting to Mark Means' request to control Lori's medical treatment. Why do you think that is?
You know, what I find interesting is that Wood did not object to the fact that Lori was deemed incompetent, but now he is objecting to the fact that Mark Means is overreaching. And I think that that is a good move. Mark Means is overreaching here. And I think that Wood is upset not only because Means is asking for information he's not entitled to, but he also accused Wood of wrongdoing. And it's not the first time that Wood has been accused of wrongdoing. And I think he's getting tired of it. Means is claiming that Wood withheld certain information, and that's just not the fact, at least according to Wood. So I think that, in fact, Wood is just tired of seeing all of the shenanigans on behalf of Lori Vallow Daybell, and he's finally putting his foot down and asking the judge to do the same.
All right, Terri, long list of demands, but what's the likelihood that the judge grants this unusual request by Mark Means?
You know, I think the judge is not going to make the request unless we get a health care proxy. I mean, the judge has to be careful here. He has to make sure that Lori Vallow Daybell herself is making this request of her attorney and not just the attorney doing this on his own. So I think that if we get the proxy, it will be a decision that the judge can make, but without it, he can't do it.
Interesting turn of events. We'll see how that plays out. Thank you, Terri. When we come back, breaking down legal arguments as Derek Chauvin prepares to be sentenced. The state now asking a judge to deny his request for a new trial and more. Welcome back. Ahead of Derek Chauvin's sentencing next week, prosecutors are asking that the defense motion for a new trial be denied. Angenette Levy is back with more of what prosecutors are saying in the newly filed documents.
Yeah, Brian, the state is arguing very strongly against Derek Chauvin being granted a new trial, and they say that no misconduct occurred during the trial.
We, the jury, in the above entitled matter as to count 1, unintentional second-degree murder while committing a felony, find the defendant guilty.
Derek Chauvin was found guilty of 3 charges earlier this year for the murder of George Floyd. The ex-cop wants his convictions thrown out, saying he didn't get a fair trial. But prosecutors disagree, and in court documents note that the defense did not use all of its peremptory challenges or strikes for jurors without cause. And the state says public accounts by juror number 52, Brandon Mitchell, demonstrates the jury carefully followed the court's instructions and did not consume news. Law&Crime spoke with Mitchell after the verdict.
Once you're in the courtroom and you're there and you're a human being and you're watching somebody die on a day-to-day basis, the stress and the emotional draining and the mental drainage that causes, you don't even think about anything going on outside of there. You're now engulfed in watching these videos and hearing this agony and this pain.
But Chauvin's defense says Mitchell didn't disclose that he participated in a march on Washington and is requesting a hearing. A photo surfaced of Mitchell wearing a Black Lives Matter hat and a t-shirt last summer marked "Get Your Knee Off Our Necks." Prosecutors say there's no evidence to suggest that impacted the jury's thought process.
I don't know Black Lives Matter as an organization.
Okay.
I don't know it as an organization, so maybe I don't know if that's how the question said. I don't know if it said Black Lives Matter organization. I don't view it as that, so I don't. Okay. That's not how I subscribe to that.
The state also denies any misconduct alleged by the defense for statements like this.
Because you're afraid that he would come to with no pulse and rampage the city. That's the sort of thing you see in Halloween movies, ladies and gentlemen, not in real life.
Now, Derek Chauvin faces up to 40 years in prison when he is sentenced. In court documents, prosecutors have actually asked for a sentence of 30 years, while Chauvin's defense has asked for probation and time served. Brian?
Thanks, Angenette. Tammy, Chauvin's defense team wants a mistrial, claiming one of the jurors did not disclose that he attended this march, as we discussed. Do you think that's enough for a mistrial, though?
Absolutely not. I don't think it's enough for a mistrial. I think that the defense is playing coulda, woulda, shoulda. They should have caught that prior to and moved to strike that juror if that they would have diligently done what he was supposed to do in order to strike the juror. At this point, we have the conviction on all 3 counts. And next week on June 25th, Chauvin is up for sentencing before this judge, who has clearly stated that he would be considering an upward departure as well. So I think right now the defense is doing everything they can do to avoid having to go to sentencing in this matter.
Could've, would've, should've is probably the best way to say it there. Terri, the prosecutors argue that the defense did not use up all of their peremptory challenges. Does that argument succeed here?
I don't think it succeeds here. I do think that there is no question this juror withheld certain information, but the real issue is, did that information cause a change in the deliberation? So it's really not the fact that the challenges weren't used. I mean, it's a good point, but I don't think that's the point that will enable the prosecution to succeed. I think the point that the prosecution is going to prevail on is, even if this juror did wear that T-shirt, went to the march, had these beliefs, none of that affected the deliberation. So I think at the end of the day, we're really going to see that this verdict is going to hold up. As Tammy said, I mean, he was convicted on all counts, and I definitely think that we're going to see the sentencing and the upward departure on June 25th.
Absolutely. And of course, what questions were asked? I think it's an issue as to, did the defense attorney ask the proper questions to elicit the proper answers? Not sure, but Tammy, Terri, thank you very much. And thank you for joining us here at Law&Crime Daily. We'll see you next time as we discuss justice in America.